So the purpose of this video is to help attorneys who are dealing with a custody case. It's a little bit more technical than what pro se litigants are interested in hearing. I'm getting into something a little bit more technical today. So all lawyers are familiar with the concept that in a bench-tried case, you can request written findings of fact and written conclusions of law. And you can make that request in a motion prior to the trial, and that triggers an obligation in some situations on the court's part to make those written findings. And then if the court fails to make the written findings, you can get the case reversed if the judge does not rule in your favor. So we're all familiar with that. We know how that works, and you do see that pretty frequently. However, not everyone is familiar with these specific rules that relate to child custody trials. So section 452.375.6 requires that in a situation where the parties have not agreed on custody and the case goes to trial, the trial court is required to make written findings as part of the judgment. So specifically what that statute provides is that if the parties have not agreed to a custodial arrangement, or the court determines that such arrangement is not in the best interest of a child, the court shall include, it says shall, so the court is required to include a written finding in the judgment based on public policy in subsection 4 and each of the factors listed 1 through 8 of subsection 2. So basically what the court has to do is they have to basically go through the custody statute, those 8 custody factors that we have in a different video, and make a written finding on each one. The court has to do that even if there hasn't been a motion filed prior to the trial. Okay, so that's all fine, and that's potentially a reversible error if the court doesn't do it. Now, one of the things that can happen, though, is that if, as an attorney, you're going to pick up a file after the case has gone to trial, but before your notice of appeal is due. And you may look at that judgment, and the judgment may not include those written findings. So you may initially think, well, great, I can go ahead, the court's required to do it by statute, I can go ahead and file a notice of appeal, I'll get this case reversed, it's a slam dunk. Well, hold your horses, because it's not going to be that easy, and if you don't do anything else, you're probably going to lose. So you probably know that for most bases for filing an appeal in a family law case, you don't need to preserve arguments in a post-judgment motion for the most part. However, this is a unique situation. You actually do need to do it. So there's a case where it's J.D. versus L.D., and this is from the Eastern District, Missouri Court of Appeals from 2015. And in this case, one of the parties filed a notice of appeal because the judge hadn't entered those written findings. The appellant, the party appealing it, didn't file any kind of a post-judgment motion. And so the Court of Appeals said, yes, the trial court failed to make those written findings as required by 452.375.6. Sure, the court didn't do what they were supposed to. But, appellant, you failed to preserve that argument in a post-judgment motion. And therefore, we can only review your case based on the plain error standard. In other words, you're not going to win. So the case was affirmed, the appellant lost, even though the judge made a mistake, the appellant didn't get a do-over. So the key here is that if you pick up a file and you see the judge has not made that written finding, those written findings, you must preserve your bases for the whatever basis you have or bases you have for that appeal in that post-judgment motion if you want to prevail on the appeal.